Leading questions under Qanun-e-Shahadat order. Introduction. A leading is a questions framed in such a manner that if throws a hint as to or suggests directly the answer which the examiner desires to elicit from the witness. Therefore, questions should be put to him about relevant facts, and then he should be given the fullest freedom to use his personal knowledge to answer these questions. Relevant provisions, Article 136 to 138 of the Qanun-e-Shahadat Order 1984. Definition of leading questions. Any question which suggests that answer which person who puts it wishes or expects to receive is called a leading question. Questions regarded as leading questions following are the questions which regarding as leading questions. A. Questions assuming a controverter fact. A question is leading where the question assures any fact which is in controversy so that the answer may really or apparently admit the fact. B. Questions calling for answer yes or no. A question admitting of being answered by a simple yes or no is regarded as generally a leading question. C. Alternative question. A question is an alternative from e.g. The question do you or did you not refuse does not admit of an answer by a simple yes or no, where the question in this form is leading or not depend upon whether it does or does not suggest any particular answer. When should leading questions not be asked? The following points are important to explain it under Sec 137 of the Qanun-e-Shahadat Order 1984A. Examination in chief or re-examination. According to Article 137 of the Qanun-e-Shahadat Order 1984, the leading questions cannot be asked in examination in chief or re-examination, but this article also describes some exceptions. B. Objection of adverse party. It is a right of adverse party should arise objection against asking any leading question. In fact, it has been provided in Qanun-e-Shahadat that leading questions cannot be asked in examination in chief or re-examination when adverse party objects such question gives exception. An exception also be provided that leading question can be asked when court permission to ask leading question during examination in chief or re-examination, but if opposite party objects, then court can decide matter and can exercise its discretion either to permit a leading questions or disallow it. When court can permit leading questions under the following circumstance, court can permit leading questions as introductory matters. A witness may be asked about matter preliminarily to the main topics of controversy. E. Witness's name, age, residence, etc. B. In undisputed matter, a leading question may be asked in examination in chief in undisputed matters to being the witness as soon as possible on the material points on which he is to speak. Counsel may lead him a non to that length, may tell him the acknowledged facts of the case which have been already established. C. Proved matters court can permit to ask. Leading in examination in chief or re-examination when court opines that the matter already sufficiently proved. When leading questions may be asked, the leading questions may be asked in cross-examination. Examination in chief. The leading questions can be asked in examination in chief if court permit to ask leading questions. B. Re-examination if court permits leading questions party when calls some witness can ask leading questions to such witness during re-examination. Conclusion. To conclude, it can be stated that examination includes examination in chief, cross-examination, and re-examination, and examination in chief, cross-examination, and re-examination all make one statement. Basic purpose of such statements to extort truth so as to dispense complete justice. However, asked of leading questions in examination in chief or re-examination can defeat this purpose. Due to this reason, it has been provided that leading questions should not be asked